While searching for information, do you keep finding lawyers who are just selling their services instead of answering your questions? With 24 years of experience, I'm familiar with the frustrations you may have while making an injury claim through an auto insurance company. I do my best to actually answer your questions in these videos and in my free book. I am Arizona native and attorney Kevin Fine, and in this video I answer your questions about what a deposition is. In modern litigation, the deposition may be the most important discovery tool. A deposition is the opportunity for opposing sides to ask questions of the witnesses on the other side or even their own, including the plaintiff and defendant, before trial. Just about anyone who has knowledge of any facts bearing on the claim can be deposed, except for the lawyers, as they don't have independent knowledge. If you want to depose one of the defense witnesses, including the defendant, then you would send a notice of deposition to the defendant through his attorney. This document states who will be deposed, as well as when and where. It is customary to consult with the defense attorney on the time and location to make it reasonable for everyone, and then send the notice with the agreed upon time and place. The defense attorney could extend you the same courtesy when setting your deposition and sending you a notice. A typical deposition is held in a conference room. The court reporter puts the witness under oath, making the deposition admissible in court for any purpose not otherwise prohibited by the rules of evidence. The defense attorney will be there, the person being deposed, and you. The court reporter, of course, will also be there to transcribe everything that is said in the room. This guide assumes that you are representing yourself, so you will be asking the questions if you scheduled the deposition. However, in your case, you may not be taking any depositions, especially if liability is clear. If the driver admits that they are responsible, you may not have anything to ask them. Then the dispute is really over what the claim is worth, which is not determined by how the accident itself occurred. However, even in a clear liability claim, it is still maybe good to ask the defendant how the accident occurred and make sure they aren't trying to blame the collision on someone else or something else. On the central dispute, proper compensation for your harms and losses, you'll have little to add. Even if you do not take any deposition, the defense attorney will almost certainly take your deposition to fully explore your claim that you were injured, how severely, how long, the treatment, past injuries that might contribute to what you're experiencing, your lost income, etc. The attorney will ask many questions, even some that don't seem relevant to you. The rules allow a lot of exploration in a deposition. Even things that would not ultimately be admissible in court can be explored in a deposition. And again, what you should answer versus what you do not have to answer is fact-specific and depends on your case, so I can't tell you here. If you really think the deposition is going outside the proper boundaries, you can stop the deposition and reach the judge for a decision. After the deposition, you can either order the transcript or pass until you think you need it. The deposition is admissible for a wide variety of uses in court, so it is usually wise to have a transcript. This can be ordered from the court reporter and in hard copy, electronic version, or both. You will pay the court reporter for time spent on any deposition that you schedule, but the charge for a transcript is separate. The defense will pay the court reporter for the ones that they schedule, like yours. Each of you will pay for any transcript you do order. I answer more of your questions in my other videos, articles in my firm's website, and in my free book. Because your situation will be different in significant ways, the general information I presented here may not be right for your matter and is not legal advice. If you wish to talk to me about your concerns more specifically, I do offer a free consultation. You can set up that visit, or you can order the free book through the contact information on the banner below. Thank you.